Right, hello, good morning, good afternoon, good evening, depending sort of where in the world you are. And welcome to Al-Tamimi's webinar today to discuss some important updates in the dispute resolution space, in particular in the GCC states. Before I go on, just some brief housekeeping matters. So look, we want to make this as engaging and enlightening as possible and as interactive as possible. So obviously we very, very much welcome questions, from all participants. But if I can ask then, if any questions you have, you plug them into either the Q&A section or the chat section within the Zoom function. And we will then allocate some time at the end where we'll try and bring those questions together and we can put them to our team of panelists. All right, guys, so commercial litigation, sort of in particular on a cross-border basis now, is increasing globally. And the GCC is no exception. So research by Law 360 in January 2022 indicates that of all companies surveyed, 59% of companies globally expect an increase in volumes of commercial litigation. And I can confirm on behalf of Al-Tamimi that what we see before our eyes and what we see with our clients confirms that. However, the obtaining of a legal judgment or an arbitral award, whether locally or further afield, whilst representing a moral victory, is not really the end of the process. Rather, without being able to enforce your judgment or your award locally, what is then the practical or commercial value of that judgment or that award? And as many of you will know and appreciate, the enforcement of foreign judgments or arbitral awards is a very complex field. And it's one that's governed by a blend of bilateral and multilateral conventions and treaties, as well as jurisdiction-specific laws, rules, and indeed procedural requirements. As Galileo is mythically alleged to have said, the mechanism of the heavens was clear, but the mechanism of the courts continues to remain murky. Okay, so to shed some light on this very technical area and to help us sort of decipher it and make it clear, we have a panel of experts from Al-Tamimi's offices across the region, who I'd like just to introduce very briefly. In no particular order, we have my colleague Naief Yahia. So Naief is a partner and head of litigation for our Dubai office, has been with Tamimi since 2009 and has been in Dubai since 2006, has a very broad spectrum of experience in litigation with particular bias on construction, commercial, banking, and property. We have my colleague Roy from Qatar. Roy is the head of our litigation practice in Qatar, is highly experienced in, again, the full spectrum of disputes before the Qatar courts, and has a track record of successfully advising both international and local clients in disputes of various natures, including banking and finance, real estate, employment, and construction. We have my colleague Rita Jabaddal, who is a partner in Al-Tamimi's dispute resolution practice focusing on DIFC and ADGM in particular. Rita is a solicitor and barrister of the Supreme Court of Victoria and has, once again, considerable depth of experience handling complex, high-value local international disputes. And prior to joining Al-Tamimi, was practicing with a leading international counsel based in Australia and in London. We have my colleague Emad Salameh, representing our Saudi office. Emad has been with Tamimi since 2007, has a broad spectrum of litigation experience, and again represents both domestic and international clients in a wide range of dispute matters. And last but not least, we have my colleague Noor, who is the head of litigation for Tamimi within Bahrain, has over a decade's experience advising on in particular high value construction, real estate, and insurance related matters. So there's our panelists. Before going further, guys, and handing over, look, us lawyers, we love definitions. So just some sort of key definitions to bear in mind as we go. When we talk about foreign judgment, we're talking about a judgment issued by a court outside of this region. Local judgment is obviously a judgment issued by a competent court within this region. That may be a GCC judgment, a judgment issued by one of the GCC, a court within the GCC state. And then we have local arbitral awards. So that would be an arbitration award originating in a state here, or a foreign arbitral award, and that would represent then an arbitration award, originating from a country outside of the GCC. So enough talking from me, and it's now time really to get into some Q&A with our panelists. So I'd like to start with Bahrain. Obviously, I'm based in Bahrain. I'm head of the office here, and it's, and I have a slight bias for that. Noor, I understand that there's been some recent developments and changes to the regulatory framework that relates to enforcing securities in Bahrain. Can you sort of briefly take us through that and let us know what we need to know?
Thank you, Rad, and apologies for my voice. Before we get down to that, I think it's very imperative for us to highlight that the long-awaited law of enforcement, which has been recently introduced, was a result of the continuous frustration of lawyers and claimants, if we may say, from the relatively relaxed process before the Court of Executions. Despite many steps taken by the Supreme Judicial Council, we believe that the lengthy process was the most common criticism back in the days. In fact, we've seen some instances where the claimant struggled for months before actually started to see some actual or successful results. And hence the objective of the new law is to basically introduce a sort of a new mechanism that is more accessible and more practical in terms of enforcing judgments. Now, in terms of what would be an enforceable judgment, generally contracts and agreement do not directly fall within the ambit of the law, but rather they will require a court proceedings where the claimant should seek the court assistance and reflect that agreement on a judgment, and later on enforce that agreement before the Court of Execution. The main enforceable documents in Bahrain will be local judgments, obviously, but the enforceable document will include the verdicts issued by foreign courts once they are ratified, GCC countries' verdicts as well, arbitral awards once they are ratified, notarized mediation settlements, and acknowledgement once they are notarized as well. Now, in terms of enforcing commercial securities such as guarantees, property mortgages, business mortgages, and so on, as long as the enforceability clause is contained within that document and the general legal requirements are satisfied within that document, then it should be enforceable directly before the Court of Execution.
Excellent. So, I mean, essentially, Noor, if I'm understanding you correctly, there's been, as a result of feedback really from lawyers from, the legal sector in Bahrain, there's been a streamlining of that process now in Bahrain.
That's correct, yeah.
Right. And in terms of sort of first-hand experience now, okay, the legislation is there, but are you actually seeing this on the ground, and you're going to court and you're able to now benefit from that streamlined process?
I think there are many differences between the new enforcement law and the previous one. Lawyers and claimants are still trying to sort of cope with the new mechanism established by the new law. So I think it will take some time for us as lawyers to sort of adjust with the new changes provided by the new law.
Thank you, Noor. I mean, it sounds very, very promising. If we sort of maybe then compare that, if we sort of look at the UAE, Naief, as Noor is saying, there's been as a result of lawyer feedback and feedback from the legal industry, the government has responded in seeking to streamline and clarify and speed up the enforcement process. How does that compare with, what's going on in the UAE?
Yeah, thank you, Rod, and thanks, Noor, for the introduction. I think it's a very interesting topic because it seems to me that all the governments in the Middle East are trying to kind of, I wouldn't say compete, but it seems like there's a lot of legislation reform in the Middle East recently, especially in the GCC countries and some of the other Arab worlds, which is very healthy for investors and investment in general. It's very, stressful for lawyers and judges, obviously, because you're, as Noor mentioned, you're trying to cope with the recent changes, a lot of reform of legislation. In the UAE, a lot of you know that we have, the UAE government undergoing a lot of reform, including the civil procedures law. A lot of changes happened the last couple of years, not only once, couple or three times actually. if you compare it with what happened in Bahrain, I think it's very similar. Although I would say that in Bahrain, the new enforcement law had a couple of elements that does not exist yet in the UAE, including this issue of privatization of the execution process. While noting that the UAE government announced last year that they are working on this project for the privatization of the enforcement procedures in general. The other element in Bahraini law that I haven't witnessed here yet is the issue of penalties of dissipation of assets of judgment debtors, which is very promising. It's very strong tool to prevent dissipation of assets by judgment debtors in Bahrain. I think it will be very helpful. And it doesn't exist in the UAE as yet, but it does exist in the UAE through different laws, including bankruptcy law, for example, but it's not under the civil procedures law, which is something that we would expect to see in the near future following Bahrain recent changes to the execution or the civil procedures law. I think the other thing that I like in Bahrain is the issue of compelling the judgment debtor to disclose his assets. This is very positive. We don't have in the UAE yet in the onshore courts, but I think we are doing it through warrants of arrests. For example, the execution judge issues warrants of arrest against the judgment debtor, but it's not as effective as what is as it sets out in the Bahraini new enforcement law. And I think this principle of compelling the judgment debtor to disclose his assets or the details of his assets, it's a common law principle, and I think perhaps Rita can shed more light from her experience in the DIFC and ADGM courts.
Rita, I think you're on. Your mic's on mute.
Thanks, Randy.
There you go.
This is a very interesting area, and it's one that makes the DIFC a very attractive place to litigate. So for those who are not aware, the DIFC is a financial free zone that sits within the UAE. And within the DIFC, we have our own laws and regulations based on English common law. It is in fact codified common law. And the processes for enforcement mirror that's in the civil procedures law. So there's two things to highlight when you have a DIFC judgment. The first is there's post-judgment freezing orders that also include disclosure orders that compel the judgment debtor to produce on affidavit a list of their assets. And the affidavit is sworn under oath. If you do not comply with that freezing order, you could be found in contempt. The second process that we have that is really unknown, I think, in the UAE is a process of examination of judgment debtors. It's called the Part 50 examination. So when you have a judgment, whether it's issued by the DIFC court or a judgment that you bring into the DIFC to enforce, you can compel the officer of the judgment debtor or the individual to attend court in person and give evidence under oath of their assets, and they will be cross-examined by the enforcing party's lawyers. And if you don't show up, if you give false information under oath, again, that leads to all sorts of consequences, not least of which are perjury and contempt. So that's why the DIFC has become such an attractive forum now for enforcement and to bring judgments in and then take them out. And we'll discuss that in more detail later on.
Yeah. No, thanks. That's very, very interesting, guys. I mean, you know, I'm sort of qualified out of the UK, and that kind of process you're talking about there is you know, something I'm more familiar with, you know, from a common law system than what you would find in the codified systems, you know, within the GCC. And I find it very interesting as well that, you know, Bahrain is kind of taking a charge there in terms of bringing that in. And if I'm guessing correctly, aside from DIFC and so on, is the first onshore jurisdiction in the GCC that has those provisions that can compel that disclosure of assets, you know, by a respondent. Is that right?
I mean, certainly in the UAE, the DIFC, and to a lesser extent the ADGM.
And Bahrain Right. And look, I think from a sort of an FDI perspective as well, as you know, as Naief said, look, there is a competitiveness between GCC jurisdictions to make the legal regime as clear, as transparent, as efficient, as fair as possible when compared to neighboring states and so on, all with sort of one eye on bringing in FDI. And you know, being based in Bahrain, I'm very pleased to hear in particular that Bahrain is sort of taking the charge on that. Going back to sort of onshore, then UAE, Naief, I understand as well that I think there's been some changes relating the use of checks as security in the UAE. Is that right?
Yeah, that's correct. In 2020, there was an amendment to the commercial transactions law where, I mean, the effective date is January 2022, but it's a very interesting reform that actually provide that the checks are no longer I mean, decriminalizing the checks is now is the situation in the UAE since January 2022, which is more or less positive change in for the benefit of the economy. Obviously, some of the creditors, including banks, don't like this change, but the good news is that you have a direct enforcement remedy under the law whereby you can go directly and obtain an execution deed on the check and open an execution file directly against the issuer of the check, which is, I mean, it's helpful to creditors by all means because it's a very quick procedures. You can get it in few days. You can get a travel ban immediately when the judge issued the order to open the execution file, which more or less achieve what the creditor wants from any criminal proceedings, that you stop your debtor from flying out of the country. So right. I think that this is a very major change that happened in Dubai, effective from January 2022. But I think also there are other countries are following the same changes in the region.
Thank you, Naief. On that point, you know, if I could bring in Roy from Qatar, you know, what's the position, what's the comparable position in Qatar with respect to the use of checks as securities? Again, I understand there's been some developments there.
Yes, we don't have the same development like UAE about the checks. However, the guarantee checks, now you cannot use the criminal court with the guarantee checks. You can go to the civil court, but with, as Naief said, was a faster track. So, but it's something interesting what UAE mentioned now, because in Qatar, for example, more than 90% of the criminal cases related to bounced checks.
Right.
So maybe they take similar action because the number of the bounced checks cases is huge. So maybe they are thinking about something similar. And just to comment on the first topic about the enforcement, it's nothing specific here, but just it's worth to mention about establishing the investment court in Qatar. Now it's effective in May 2022. There is nothing very specific to the enforcement, but in Article 32 it says that specific judges will be appointed with more employees. So we are expecting development in that area as well to be more efficient. And because during the pandemic and after the pandemic, we noticed a lot of development in Qatar court system. Yep. Not too much in the enforcement, but after this law 21 about establishing the investment court, we are anticipating more and more development in that area. Thank you.
Very good. Thank you, Roy. So, you know, based on what I'm hearing here in terms of Qatar and Bahrain, UAE in particular as examples, we're seeing very positive developments, okay? You know, improvements in those processes, the increased efficiency and increased clarity. With that in mind and sort of thinking about, in particular, foreign direct investment, investor confidence, and so on, okay? if we sort of move on to the topic now of, submission, contractual submission to, for example, the jurisdiction of foreign courts, okay? As a corporate lawyer, I get asked this question a lot, okay? In a contractual negotiation, especially on a cross-border basis, the parties will say, well, actually, we're negotiating with a party in Bahrain, we're based maybe in America, and we want to submit exclusively to the jurisdiction of maybe the courts in London, okay? Because maybe there's a perception that those courts are clear and transparent, and there's less concern about neutrality and so on. So if we look at Bahrain, for example, Noor, where parties are contractually agreeing that, the courts of a foreign country will have jurisdiction over disputes, okay? Would the courts in Bahrain respect and uphold, a provision of that sort?
Generally, Rad, the courts in Bahrain tend to recognize this jurisdiction irrespective of the parties' agreement to submit to any other foreign jurisdiction based on its territorial competency. This is very likely derived from the international concept or principle that the court should never abandon its sovereignty to any other court of law. And as such, it is very unlikely for Bahraini courts to dismiss a claim simply because there is an agreement between the litigants to submit to another jurisdiction. To the contrary, if the parties agree on arbitration, it is very likely that the court will uphold, or definitely the court will uphold the agreement on arbitration once that argument is raised and the first defense between the party who is benefiting from that defense.
Interesting. So if I understand you correctly then, Noor, if parties submit to the jurisdiction of foreign courts, there's no guarantee the court would uphold that. But if the parties have clearly submitted to arbitration, and that's raised by one of the parties, the respondent, right? Yeah. The court in Bahrain would uphold that. They would honor that submission.
That's correct. So the agreement on litigation before another court and the agreement on arbitration are being treated very differently in Bahrain, and I think in most of the jurisdictions. So if I agree on litigation in another court, the Bahraini courts will perceive that as interference within the sovereignty of the country, and it's very unlikely for the Bahraini courts not to recognize its jurisdiction in this regard.
Very, very interesting. If we go down the road now and sort of look at Saudi Arabia, for example, Emad, what's the, Noor has taken us through how it would work in Bahrain for submission to foreign courts and submission to arbitration. What's the position in Saudi Arabia?
Yeah, thank you, Rad and Noor. I like, unlike the situation in Bahrain, in Saudi, the situation for submission to foreign, the jurisdiction of foreign courts or arbitration are similar. If both parties agree to submit to a jurisdiction of foreign court or arbitration, the Saudi court would uphold that agreement based on the general principle that the contract is the law of the parties, unless they entered or entered to the subject of the dispute without raising this defense in the first hearing or before submitting to or entering into the subject of the dispute itself. So the KSA courts, we have judgments dismissing the case for lack of jurisdiction due to this agreement between the two parties.
Interesting. And tell me, Emad, you mentioned that provided it's raised early enough in the process as a defense, that the court would uphold that. Now, I know of jurisdictions in the region where, even if that's done, you would still have to go through the full trial, okay? And the court would only then give its ruling on the jurisdictional issue, right at the end of that process. Is that how it would work in Saudi Arabia? Or from, day one, if that defense is raised and it's properly raised, the court would then decline jurisdiction?
That situation was previously where the court would ask both parties to submit their full defense, formal and on substantive side of the case, and issue a judgment on both, covering the jurisdiction. But the recent, development, the court would decide on the formal defenses, including the jurisdiction at the early stage of the case, then proceed.
Excellent. So you could avoid effectively going through the substantive,
the lengthy process.
The lengthy process, which again, I think is a very, very positive development, and one that's very reassuring to parties, in particular, where there's an international nexus. We're talking about submission to the jurisdiction of foreign courts, and as Noor alluded to in Bahrain, and I'm sure there'll be instances in other GCC states where, if the courts did accept jurisdiction, or in a scenario where the parties do submit to the local jurisdiction, we agree that we'll go to the courts of Saudi, or indeed the courts of Bahrain or UAE and Qatar and so on. But we agreed that the contract, the substantive law of that contract, was governed by a foreign body of law. So, for example, I agree with Party B that, the Saudi courts will have jurisdiction over our disputes, but the applicable law to that contract, the substantive law, would be, for example, and I have a bias again, English law of England and Wales. Generally, would the courts, for example, in Saudi, would they uphold that, Emad?
Unfortunately, no, because it's clear according to the law that, and the basic law of Saudi Arabia, that Saudi laws, Saudi court will not apply foreign laws on any case that they're accepting jurisdiction to hear. So this will not be upheld by the court.
And you could expect the court then to apply Saudi law, basically, irrespective of Emad, right? What about, thank you, Emad. What about if we look at UAE, Naief? What's the position there on the same set of facts, and the parties, submit to local courts with English law, US law, as the case may be? Would the onshore courts in the UAE respect that?
Yeah, okay. I mean, with respect to the application of foreign law, in theory, it is possible. So under the civil transactions law, it is allowed for the parties to agree on a foreign law to govern the relationship. However, in practice, it's very difficult. We have not seen it in commercial or civil disputes where judges prefer to apply the UAE law despite the agreement between the parties on foreign law. But we see it more in family law cases where judges are compelled by the personal status law to apply foreign law in certain cases. But in commercial and civil transactions, it's very difficult, and I have not seen it personally where a UAE judge applying foreign law. But in terms of the jurisdiction, I think the position in the UAE is very similar to Bahrain, where you cannot agree on a foreign court jurisdiction and deprive the UAE court from its own jurisdiction. And that's why our standard advice in the UAE to clients is to, if you would like to apply English law, or the example you gave, Rad, then you better go with the DIFC and ADGM courts or arbitration instead. Don't ever agree on UAE courts while you would like to apply foreign law or English law in particular.
Thank you. No, that's interesting, Naief. And Rita then, Naief's saying, referencing the DIFC in particular as a sort of safe option in those circumstances. What would you say to that? And what would your advice be, for example, to a client who is a bit nervous about potentially, the application of UAE law, or that the UAE courts may accept jurisdiction?
So that's, again, what makes the DIFC and ADGM such an attractive option for a lot of clients, because the court will uphold a party's choice of governing law, whatever that law may be. So I've been involved in cases where we've applied Swiss law, we've applied Kuwaiti law, we've also applied UAE law in the context of a DIFC court proceeding. And that evidence can be adduced by submission, it can be adduced by experts on that particular law, but there's no impediment to the court applying whatever law the parties choose. And they're applying it in the context of a common law proceeding,
right,
which may be familiar to a lot of international clients, in particular doing business in the Middle East.
right.
But Rod, if you allow me to interject here, because it's not straightforward, although it may appear like the parties are free to choose the foreign law, but that is not applicable on all cases. For example, commercial agencies disputes that are registered with the ministry, you cannot agree on a separate jurisdiction or DIFC or elsewhere.
Right.
Or apply foreign law, because the commercial agencies, registered commercial agencies, are subject to the commercial agencies law in the UAE. So there are obviously exceptions to the general rule, but obviously there's a lot of them, but we're just covering it from a general perspective.
But can I just add to that, just on that exception, one exception that might be of interest to our clients who have joined us is where you have nominee agreements and you have companies incorporated in different emirates. We've had nominee agreements have DIFC courts and DIFC law as the governing law and the forum for that dispute. And the courts have heard those disputes, irrespective of what the MOU says. And so I think, you know, there's a lot of, you know, evolving case law on this, but we've certainly been able to get DIFC freezing orders in respect of nominee agreements for companies incorporated in Fujairah and Ajman, for example, where the parties in the shareholders agreement and the nominee agreement have chosen ADGM or DIFC. So that's, you know, that's quite an interesting and very recent development.
That is very interesting. So I think, you know, if I may say, guys, I suppose the key takeaway from that is it's going to vary case to case and circumstance to circumstance, depending on, you know, where the parties are, what laws you seek to apply, whether or not there's applicable mandatory laws, as Naief says, you know, commercial agency law and so on. And I suppose the key point is, you know, call your local friendly Tamimi lawyer and get advice on that to make sure that, you know where you stand on that and have some degree of certainty on it. Also, just before I go on further, I'd just like to introduce my colleague as well, Omar Al-Qahtani. I think Omar had a technical glitch earlier, so he's dialed in. Omar is head of our litigation practice in Kuwait and you know, has many years experience there. And it's a pleasure for Omar to be joining us also. So thank you, Omar. Okay, guys. In terms of GCC judgments, okay, and this is something that, you know, I personally don't know myself and I find very interesting. What is the mechanism then for enforcing a GCC judgment? And by that, you know, I'm referring to a judgment that's been issued by, you know, a competent court within a GCC state. Noor, could you perhaps give us a sort of an overview of that and let us know, for example, is it required to initiate a fresh claim before the local court, or, you know, or what is the process?
I think that would be the 1 million question, because the position might vary from one country to another. But according to the GCC convention, generally any GCC state member may allow the enforcement of judgments that were issued from another GCC member. So ideally, you will take you will be treating the GCC judgment in the same manner of treating a local judgment, which is the position in Bahrain. We have some sort of discrepancies in terms of how would the court or the execution courts would apply the enforcement proceedings. Sometimes we've seen some instances where the court of enforcement will require a sort of judgment ratified by the High Civil Court. However, I think the position is similar between all the courts in Bahrain nowadays. So you are not required to pursue a fresh claim before the High Civil Court. You may initiate the enforcement proceedings directly before the execution court. And I think this would apply to the other GCC countries, such as Dubai and such as UAE and Kuwait.
Yeah, thank you, Noor. That's, I think, again, reassuring to a party, you know, that provides that sort of reciprocity then between those GCC states. And, you know, if we sort of bear that in mind, then, you know, if a party was going direct to enforcement proceedings, so for example, a judgment issued out of Bahrain, and a party then seeks to then take that direct to UAE and enforce that before the UAE courts, what could a respondent do to try and challenge the enforcement of that judgment, Naief, you know, within the UAE?
Yeah, thank you, Rad. I think there are certain criteria that the respondent can raise to set aside the judgment or the enforcement application filed in the UAE pursuant to the GCC Convention itself, Article 2, which provides a set of rules with respect to setting aside any enforcement application before any of the member states, and that includes, I mean, for example, if the judgment is against public policy or against Sharia principle, if the judgment is in absentia and the judgment debtor was not properly notified with due process, and that the judgment didn't follow the due process for service. Another example is that if there is another judgment that was issued in the UAE, for example, that is actually against the judgment from the other state, that's another example where you can raise a defense to set aside the enforcement application. And another example is that if the judgment is against any of the governments of the GCC countries, that is not enforceable based on the GCC Convention. So those are examples of how you set aside the application to enforce a GCC judgment in the UAE.
It's very interesting, Naief. Thank you. And in practice, then, have you seen that in practice successfully, where you've managed to prevent enforcement of a GCC judgment on the kinds of grounds that you spoke about there?
Yeah, I mean, talking about enforcement, it's now similar position like Bahrain. It used to be through an enforcement action that you have to file a case before the court of first instance not to ratify, but to declare that the judgment is enforceable. But recently, in a recent changes in the civil procedures law, now you can go directly to the execution. I haven't seen any judgment that was set aside by the execution court in Dubai, but we have seen judgments or actually orders from execution judges enforcing GCC judgments recently since the amendments of the civil procedures law a couple of years ago. So that's a positive development. It's a very speedy process where you can apply to the execution judge by way of an application to enforce a GCC judgment.
Excellent, thank you. Omar, what's the position in Kuwait on that regarding the enforcement of a GCC judgment and the process to try and challenge that pre-enforcement?
Regarding to the Kuwait in a practical way, because here that what Noor mentioned, there is a convention, Riyadh Convention and Oman Convention, and the Kuwait Parliament, or the Parliament is agreed and vote to apply the Oman Convention. But unfortunately, practically, once we bring the judgment from any country from the GCC, unfortunately, we faced that they stopped, and again, they referred to the Article 199 and 200 procedure law. So we must, or we should, file a case before the court in Kuwait, but the Kuwaiti court will never be involved in the subject itself. The Kuwaiti court only will check in the formalities as the foreign judgment, as the judge is issued from the final judge, considered as a final judgment. The parties will present in the case itself. So the court will only just review and check the formalities. But the thing is, here what we face, and practically some judges in Kuwait, they refuse the case based on the interest. So some jurisdiction, like for example, in Dubai, the interest is, if I'm not mistaken, 11 in commercial debt.
Oh, so sorry, Omar. So we're talking interest here in terms of, a percentage of a debt, basically, that would otherwise apply. Yeah.
Yes.
Yeah.
So the debt interest. Yes.
Yeah.
So the thing is here, in Kuwait, as a public order, it's only 7%.
Okay.
So if the judgment if the judgment came from the GCC and the interest came within 11. So we ask or request from the judge to reduce it to 7%. So we cannot face the public order.
Interesting.
So in the practical, I won like 4 cases for foreign judgment. So now I'm open execution file to execute the amount and whatever.
Okay, thank you, Omar. And it's you know, and it's interesting that you bring up interest. It's actually a topic that I'm going to come on to. So,
sorry.
Yeah, no, not at all. No, listen, it's fine. And you know, and I'll bring back in your comments on that gladly in a moment. But thank you very much for those clarifications. We've spoken then, guys, you know, about the enforcement of GCC judgments. Okay, and you know, that's a judgment from a court within, you know, a GCC state. And if sort of we then extend that and say, well, okay, what about the enforcement of foreign judgments? You know, so court, you know, a judgment issued by a court outside of the GCC. What's the position, you know, both Naief and indeed Rita in the UAE with respect to enforcement of foreign judgments onshore in UAE and perhaps within, you know, DIFC and ADGM?
Sure, Rod, thank you. I think the position is very clear. We have to make a distinction between the enforcement of foreign judgments, where you have a bilateral or multilateral treaties between the UAE and the other jurisdictions where the judgment was issued, and where the foreign judgment was issued in a state that we don't have a bilateral or multilateral treaties with the UAE. Obviously, we are still struggling with the issue of reciprocity in the UAE in case there is no bilateral or multilateral treaties. And the condition of reciprocity, although the civil procedures law was amended recently, but still it does exist. It's not easy to prove. We have seen a lot of judges refusing the enforcement of foreign judgments without bilateral treaties based on the condition of reciprocity.
Sorry, Naief, sorry to cut you in there. In terms, can you just explain that concept of reciprocity?
Yes, sure. The reciprocity principle in general, it's where the equal treatment by the other state, that they accept the enforcement of the UAE judgments in the other state where the judgment was issued. And that includes not only that if, for example, English court respect UAE judgments, actually the condition itself of enforcement in the UK has to be similar to the conditions in the UAE. So it's not only that if the English courts respect the UAE judgments or enforce it in the UK, then I will automatically enforce a UK judgment in the UAE. Actually, it's more stringent than that, because you need to prove that the conditions they apply in the UK is similar to the UAE. That's why a lot of practitioners are struggling to enforce foreign judgments where we don't have bilateral treaties. And just the other issue that I wanted to cover also is that the original jurisdiction principle, where the Dubai courts or the UAE courts have original jurisdiction, original exclusive jurisdictions to look into a specific dispute, then even if you have a judgment from a foreign court, the UAE judges will still refuse the enforcement, because you again deprive the UAE judges from their original jurisdiction from the beginning, and therefore the judgment is not enforceable in the UAE. So it's pretty much still a gray area a bit, especially without bilateral or multilateral treaties. And that's why I think we will go to Rita and discuss the issue of enforcing foreign judgments in the DIFC, where it's much easier, obviously, and that's a selling point for Rita to talk about.
It sure is, and it's an area that we advise clients on a lot, because clients who want to bring in a foreign judgment or arbitral award into the UAE because they're chasing assets that are based in the UAE will often ask, which court should I go to? And so they have a choice. They can go to the local court where the assets are located, or they can come, leaving aside the ADGM, they can come to the DIFC. because the DIFC is what is known as a conduit jurisdiction, which means that you don't have to show that there are assets within the DIFC in order to bring your foreign judgment into the DIFC court and file a claim to recognize and enforce it. So assuming you have an English judgment or an American judgment or an Australian judgment, you can bring that in as long as it satisfies the conditions under common law for enforcement of judgments. And they're not as stringent as what they are under local law. So as long as you can show that the original court had jurisdiction to issue the judgment, it's not a judgment for a penalty or for a tax penalty, and that there was due process, then as long as it's a recognized court, and nearly they all are, the court will then enforce it. And so you have to bring a normal proceeding, you have to commence a normal claim in order to start your recognition and enforcement process. But assuming there's no defense to that, you can get summary judgment pretty quickly. And then once it's issued as a DIFC judgment, then you can take it throughout the UAE for enforcement. The position in ADGM is slightly different. The ADGM has taken a policy decision not to be a conduit jurisdiction, meaning that you have to show that there are assets within the jurisdiction, but if it's a foreign judgment, there are limited judgments of foreign courts that the ADGM courts will recognize. So two very, very different approaches. Arbitral awards are even easier. So for an arbitral award, I can actually file my arbitration claim form in the DIFC ex parte. That means I don't give notice to the other side. It means that within a week, I can get my order enforcing, ratifying and enforcing that arbitral award, and then take it for enforcement.
It's very, very interesting. Thank you, Rita. I mean, Naief has mentioned some of the practical limitations, some of the sort of the bear traps, if you will, in seeking to enforce, a foreign judgment onshore within the UAE. Now, if I understand what you're saying correctly, effectively, Rita, I mean, is it correct to conclude then that, enforcement of a foreign judgment within the DIFC can be used as a means effectively to try and circumvent those limitations and those bear traps that exist onshore within UAE? Is that correct?
That's correct. And that is not something that is yet to be tested. That is law. So we acted in the first case to test this issue. It's a case called BNB Bank, where the court of appeal, and this is now leading authority, issued a decision that there did not need to be assets in the DIFC in order to bring your foreign judgment. Wow. And that is now the position. So irrespective of JJC applications that have been filed since then, the JJC has always sided with the court that first heard that enforcement application. So it's very much recognized as a conduit jurisdiction. The DIFC court is also recognized as a court of Dubai. We have numerous authorities to that effect. So I guess Dubai did not see that circumvention as a public policy issue because the DIFC is a court of Dubai.
If I may interject.
ADGM is slightly different though, as I said. So they have taken a very conservative approach.
Okay.
Yeah, if I may interject, Rod, and I think just for your benefits, the speakers and the panelists and the audience, me and Rita have been debating this since 4 or 5 years. So I think it's an interesting topic for us. I think I do agree with Rita that the position is very clear with respect to the conduit jurisdiction of the DIFC courts. But I personally have a view on this that I don't think it's appropriate for the DIFC court to act as a conduit jurisdiction. The ADGM courts have categorically made it very clear that you can only enforce the foreign judgments if you are targeting assets in the ADGM territory. While I think what I said is supported by one of the judgments in the JGC, and just for your benefit, JGC is the Joint Judicial Committee that was established a few years ago by the Dubai judiciary to sort or refer the conflict of between the Dubai courts and the DIFC courts jurisdictions to settle the conflict of jurisdiction between both courts. And in one of the judgments, it was made clear that the Dubai courts have ultimate jurisdiction or original jurisdiction to look into enforcement of foreign judgments. However, in recent judgments in 2020, I think GGC adopted a different approach where they have respected the DIFC court jurisdiction to enforce foreign judgments, and that is in relation to one of the Singaporean judgments that was actually brought to the DIFC court for enforcement. Although I disagree with the judgment, but that's the position, the current position in GGC. But the same committee have issued earlier decisions that contradict with the recent one. So, I mean, that's the position. And I personally believe that this conduit jurisdiction shouldn't be there, but it's helpful to a lot of clients. So I don't mind. I mean, obviously, Rita will disagree with whatever I said, but just wanted to throw out this.
Yeah, I think it makes sense, Naief. I mean, I think if we're treating the DIFC as a court of Dubai, which we very much are, then it only makes sense that they have the right to enforce judgments and foreign judgments and make those as portable as possible. And because we don't have issues with reciprocity, it just means you can then access the enforcement courts in every emirate through the DIFC. And I had a case once where a DIFC judge said, enforcement is about reality, guys. And so, the reality is you're trying to get assets, you have a foreign judgment. So, I think our views on this are changing.
Yeah. But the only concern I have is that circumventing one of the public policy requirement, which is reciprocity requirement or reciprocity principle. It's not easy to do, and that's why when you use the DIFC court as a conduit, you're kind of losing this public policy principle, and that's why I have an issue. But again, in practice, you're right. It has been used as a conduit jurisdiction, and it is successful in some cases.
Yeah, but just to make clear that there are conditions that you still need to satisfy in the DIFC court. So it's not a free ride for every judgment.
Right. Now that's very, very interesting, guys. Look, I know you guys have been debating this between yourselves for many years, and I'm sure will continue for many years to come. I think partially, look, from where I'm sitting, whether or not you approve of that circumvention, if you will, using the DIFC courts, largely depends on whether or not you are the applicant or the respondent. I'm sure to an applicant seeking to enforce, it's extremely attractive, and maybe to a respondent less so. Okay, and I think it's an area that actually warrants probably another webinar by and of itself, because it is a very, very detailed area. It's something of considerable interest. It's an area that's continuing to develop, and one that I know and I'm very confident will be of great interest to a lot of our clients, and particularly those based in the UAE. We spoke about reciprocity there, and I understand if we sort of look down the road now to Saudi Arabia, Emad, I understand there's been some changes with respect to the reciprocity requirements that arguably sort of bring Saudi Arabia more closely in line with sort of regional norms and standards. Can you sort of tell us about those, Emad, please?
Yeah, thank you, Rad. Yeah, yes, the position according to Saudi law in relation to proving the reciprocity has changed. According to the previous law, the process was that the execution judge would communicate with the Ministry of Justice to provide information regarding the reciprocity with the jurisdiction issued the judgment. But now this situation has changed, and according to the new execution law and its executive regulation, the burden to prove the reciprocity now on the applicant, and there is a way to prove the reciprocity. We talked about if there is like a bilateral or a multilateral agreement between the two jurisdictions, but also now if there is no agreement, such agreement, like the applicant has to evidence that the foreign jurisdiction would recognize and enforce Saudi judgment in the same manner as the domestic judgments.
Thank you, Emad. So I think it's fair to say, by the sounds of it, then, that yet Saudi is now, as a result of that, much more closely aligned to the procedure that applies in other GCC states. Guys, we've spoken a lot about GCC judgments. We've spoken a lot about, you know, foreign judgments. If we sort of move now to sort of consider enforcement of arbitration awards in particular, maybe Omar, if you could be kind enough to sort of give us an overview of sort of what are the, you know, the key points to note when it comes to enforcing a foreign arbitral award.
Arbitral award here in Kuwait, if it issue in Kuwait as a Kuwait jurisdiction, it will, we can open execution file immediately. But if the arbitration award issued from Dubai, for example, DIFC, for Oman, from anywhere, so same the procedures that the GCC judgment, it's the same. We need to file a case, and the judges, again, they will just review the formalities of procedure, will present, and the conditions, it's famous conditions for all jurisdiction. For example, one of the things is we filed these arbitration award, and the opponent raised a res judicata based on that. So here it came involved in the subject, but the court even not be involved on that defense, and issued the judgment in our favor to enforce the arbitration award. Even though I have practically with the two arbitration award from DIFC, and plus the court, it was a 12% interest, and the court accepted in Kuwait. So here, some judges, they thought that regarding the interest, we will shift it. But again, the arbitration award, if the both parties decided the interest, so the Kuwaiti court will apply.
Okay, thank you, Omar. In terms of sort of preemptive then applications to set aside or to annul a foreign arbitral award, what's the position on that in Bahrain, Noor?
Thank you, Rad. So generally, Bahrain provided for two mechanisms or means to challenge an arbitral award. The first one would be basically pursuing a fresh claim before the courts within 3 months for grounds that relates to the formalities of the judgment. For instance, if there is absence of arbitration agreement, if the tribunal composed in a manner that is different than the arbitration agreement, if the arbitration agreement was non-arbitrable, and so on. The other mechanism is basically based on the same grounds, but the party that will be subject to the enforcement to proceeding may raise it before the courts once the enforcement to proceeding is initiated by the counterparty.
Okay, thank you, Noor. Again, on that topic, look, Roy, you know, I used to practice law, you know, in Qatar many years ago, and I remember there was a very sort of highly publicized decision of the court in Qatar, whereby a foreign arbitral award, the enforcement of that in Qatar was refused by the courts, I believe on the basis that the award had not been issued in the name of His Excellency or His Highness the Emir of Qatar. Is that right? And what's happened in that space, you know, since that very highly publicized decision?
Yeah, thank you, Rad. Actually, this famous, or I would say controversial judgment is issued by the Court of Cassation in Qatar. It has been issued like 10 or 8 years ago. And after this, for many years, the Court of Cassation issued many or a couple of judgments like fixing that controversial judgment. I think now we are on the right track, especially that Qatar, first, it's part of New York Convention, and second, we have a new arbitration law issued in 2017. And after this law, I would say that Qatari courts, especially Court of Appeal, is very pro-arbitration, like friendly with arbitration. It's very rare now to see that the Court of Appeal set aside arbitration award. So that controversial judgment, I would say, it's not exist anymore. So since Qatar is part of New York Convention, there is fast track to enforce foreign arbitration award in the enforcement court directly. No need to file a fresh case before, of course, court of first instance. You can go directly to the enforcement court. There is something specific for the interest here. I can discuss it now or later if you prefer.
Look, happy to. I mean, it's a topic that's popped up during the course of our conversations today. It's a topic that I know clients ask about frequently. And it's exactly that, you know, essentially, you know, what is the position when it comes to enforcement of either a foreign judgment or a foreign arbitral award? And, you know, that award provides, you know, for the payment of interest. Now, that interest could fall within two pots, basically. It could be the interest, which was, you know, the subject of the claim. So it might be a loan, for example, that has an interest element to it. And or the arbitral award or the foreign court may have also applied interest by, you know, a statutory level of interest on the debt itself. So I'd be very interested to hear, you know, what the position is on that, in particular in Qatar and in Kuwait and in Saudi Arabia, if possible. So if we start perhaps with Roy to take us through the position in Qatar.
Yeah, in Qatar, it's in general, the civil law didn't allow the interest in general, so it's not allowed. So however, when it comes to the arbitration award, and it says that there is original amount and plus 5% interest, which is equal 100,000, so the total will be X amount, then you want to enforce this foreign arbitration award in Qatar. The Court of Cassation stated here in Qatar that this kind of interest here, it's kind of compensation. So it's not against the public order and you can enforce it. However, if the award stated that there is original amount plus 5% interest, which is equal 100,000 plus 5% from the date of issuing the award until the payment made, then that last part, it might not easy to enforce it in Qatar, the last delay interest, if you want. But the original one, which is stated specifically in the award, the Court of Cassation was clear, stating that this is kind of compensation for delay and it's enforceable.
That's very, very interesting. How does the position compare in Saudi Arabia, Emad?
Yeah, in Saudi Arabia, as we all the colleagues highlighted on the requirements of enforcing any foreign judgment or award, one of the requirements in Saudi Arabia not to conflict or contradict with public order, and the execution law in Saudi defines the public order is the principles of Sharia, Sharia law. And if we receive any judgment that has a portion related to interest, then here there might be an issue where the judge would ask the applicant to separate the amount for the actual amount for the damage, etc., from the amount of the interest, and if submit and for the applicant to submit a letter to set aside the portion of the interest, and then proceed in the enforcement. And that applies to the interest according to the contract or an interest, awarded by the court, any interest. However, some of the judgments we receive in Saudi include the judgment as sort of compensation without specifying that amount is interest. In this case, because the execution judge will not look to the substance of the judgment, may enforce that judgment with the compensation unless the other party dispute that amount in front of the execution judge, and then he will examine, or the judge will examine that amount, whether it is actually interest or compensation for damage.
Thank you, Emad. No, thank you very much. Guys, I'm conscious of the time, and we've had, I'm glad to say many questions have been submitted. And obviously, thanks to all of our attendees for attending and for submitting those questions, and we'll try and get through as many of those as we can. In terms of the panelists, look, I will, either allocate the question, or if it's a more general question, you can raise your hand. You can do that by pressing the raise the hand button, or you can, physically raise your hand. Okay, so the first one is from an anonymous attendee. Have the UAE executive regulations amending the CPC on enforcement of foreign judgments made foreign judgments, especially common law judgments, more readily enforceable, or do further challenges remain? I think Hani would, sorry, Naief, sorry, is that one you'd like to?
I think, as I said, there was a recent amendment to the civil procedures law to the provision related to the enforcement of foreign judgments, including any types of judgments, either common law judgments or civil law judgments. And it's now much easier than before because you can go direct execution without the need to go and get a declaration through the normal means of filing cases in the UAE. So it's a direct enforcement application. However, again, it's still, as I mentioned, the reciprocity requirement is still there, which is the most challenging point that we're still struggling with. Unless you have a bilateral or multilateral treaties that overcome this difficulty, we are still facing challenges. But our advice to clients is that once you have a judgment from a foreign court, just give it to us. We will study it on a case-by-case basis and check the reciprocity requirement, and then advise you accordingly. But as we mentioned earlier, DIFC court is a better jurisdiction to explore in the UAE to enforce foreign judgments.
Thank you, Naif. Thank you. A related question, and I think it may be from the same attendee, is given the inconsistent decisions rendered by the DIFC Joint Judicial Tribunal, can we say that the conduit is alive or dead at this point in time?
Yeah, I mean, to Rita is alive, to me is dead. So,
okay.
I mean, it's a difficult one, but again, I personally don't like some of the GGC judgments, reasoning at least. But the situation now, the recent judgment from GGC is that you can use the DIFC court as a conduit jurisdiction. They haven't mentioned that, obviously, but they have respected the choice of one of the parties to go to the DIFC court to enforce a foreign judgment. As I mentioned, the Singaporean judgment example, which is something that I think it's still an issue that you cannot be certain about, but obviously based on the case law, the number of the case law that we have from the GGC, it is an option that you can explore.
Just to add to that, we're looking at it, your question relates to the JJC, but as a matter of DIFC authority, it is very much alive. So there is Court of Appeal authority.
Okay, so I think it's possibly fair to say that it's alive, although Naief may prefer that it wasn't alive. Perhaps, I don't know. Perhaps.
Just one interesting point to raise is the issue of the stay of proceedings. Yep. That once an application is raised with the GGC, the Joint Judicial Committee, the two courts should stay the proceedings. In Dubai courts, it was a problematic issue that we had contradicting judgments on, but recently we have a Court of Cassation judgment where the court decided that the courts in Dubai shouldn't decide on the jurisdictional challenge until the GGC issues its judgment. I think unlike the DFC court, it should be assessed on a case-by-case basis, and I think Rita can talk about it in more detail.
Yeah, I mean, the issue of the stay, one of the ways that someone can frustrate your enforcement claim in the DIFC courts is to file a JJC application. And we've seen delays, we've seen it take up to a year. But what has happened now is the DIFC court has said we are not staying proceedings, even though technically that's what the law says they must do, until the jurisdiction challenge is heard. So what that means is you still go through the process of having a jurisdiction hearing and the DIFC issuing a judgment. And then at that point, you could potentially apply for a stay of the proceedings pending the JJC decision. But saying that the DIFC is a great conduit jurisdiction is correct, but we can't ignore the fact that you might be subject to these delaying tactics by the other side seeking to frustrate your attempts.
Right. And by the sounds of it, Rita, you know, that can be a strategic decision by the respondent then to utilize, you know, that mechanism then to delay and drag, you know, the matter out, right? Potentially potentially successfully. Potentially,
but then what you must also know is that because the DIFC court, we hope that in a situation like that would end up being the court that could continue to hear the case, you would then receive cost orders in your favor.
Right.
Right. So you have the ability to get up to 85% of your legal costs by way of cost orders in the DIFC courts, as opposed to the local courts where it's much more limited.
Right. So that strategy has a potential cost to it then if you try to use that to, you know, there may be a cost implication. Related to that, guys, there's a question from Ahmed Al-Anani, okay, which is, if I obtain an enforcement of a foreign judgment or foreign arbitral award from a DIFC court, okay, in practical terms, how can I then execute that onshore? You know, how would I then do that across the UAE and with respect to assets across the UAE?
So from the DIFC perspective, you would take that judgment to the Dubai court. This is how we usually recommend you do it, although it doesn't stop you going directly to the execution courts in other emirates. But we would obtain execution letters from the DIFC court, and then we bring the judgment onshore. It's effectively stamped as a Dubai court judgment at that point. And then enforcement is then done under the civil procedures law from that point. So it's a Dubai court judgment. And so the process, as Naief will explain, is that the execution judge will write to the execution courts of the other emirates where you believe there are assets, and then it's enforced as a Dubai court judgment.
Yeah, I think, but from reading the question, I think what Ahmed wants also to know is about any risk of enforcement, like, because the DFC court is used as a conduit jurisdiction where it actually kind of you circumvented one of the requirements under the civil procedures law, which is the reciprocity requirement. So I think to answer that, I think there shouldn't be a problem if you use the DFC court judgment in Dubai, as Rita mentioned. However, it's not very straightforward, because if the respondent try to create a conflict with another emirate jurisdiction, like for example Abu Dhabi court, which is not subject to GGC's jurisdiction, then you may end up with a dispute and a conflict between other local courts like Abu Dhabi courts and the DFC, and in this case we end up with the High Supreme Court to sort out the conflict between the two jurisdictions, which can be problematic. I haven't seen it yet, but what we should mention here is that the High Supreme Court in a recent decision have respected the jurisdiction of the DFC court in a very clear language, that the DFC court is part of the UAE judiciary and it should be, its jurisdiction should be respected. But we haven't seen a judgment about this specific point on enforcing foreign judgments without respecting the reciprocity requirement.
I mean, I think I would just add to that, the reason we probably haven't is because the Dubai court doesn't have jurisdiction to revisit the merits of a DIFC judgment. Once it becomes a Dubai court judgment, it's civil procedure law that applies. So, you know, as a Dubai court judgment, you would be subject to whatever potential defenses you could raise against enforcement under the civil procedures law.
Thank you. Yeah, no, as I said, I think it's an area of considerable interest to a lot of our clients. There's, you know, a lot of food for thought there. It's an area that's in flux at the moment, and we're seeing sort of developments incrementally as to what's going on. And I think it's an area that we'll all watch with considerable interest, and perhaps we may do something in the future in terms of, another webinar specifically on this topic, because I know Rita and Naief have a lot more to add on this topic, and would be happy to do so. I think I've got two more questions here. Okay. This is quite an interesting one. It's a bit out of left field. It's from Hamna V. How would enforcement of a blockchain-based arbitral award pan out in Dubai, especially under the court of the blockchain, under the DIFC courts? I wasn't aware there was a court of the blockchain in the DIFC, but Rita, is there something you can shed some light on?
Right, so what we have in the DIFC is a fantastic development where the court has established a new division to deal with these types of disputes. So it's very much virtual assets, AI, crypto. It's a court built around hearing disputes with a very specialist judge. The rules of those courts have just gone out for consultation, and we submitted some comments. So they haven't been issued yet. But what I can tell you is that they're really looking to normalize enforcement of awards where the underlying assets or the underlying disputes revolve around these type of blockchain, crypto, virtual asset. So for now, we have to watch this space until we see the rules and how they deal with enforcement. But I think that the way that we would deal with it is how you would deal with it anywhere else in the world, in terms of how you would manage to enforce and execute against specific assets of the entity holding the assets. I mean, again, it all depends on the dispute, and it all depends on what the underlying judgment is. Right.
And I think, again, look, to sort of doff my cap to the UAE authorities, I think this is once again an example of, the UAE, the government, the leadership there really, taking the charge, I think, in the region for sort of being really at the cutting edge, at the curve or ahead of the curve. So a very, very interesting area indeed. Another specific question for Rita. Rita, can you talk a bit briefly about the recent changes made to arbitration in the UAE and reforms made to the DIAC? What does this mean to people still wishing to apply to the LCIA or wishing to apply LCIA rules within DIFC courts?
It doesn't change that at all. So as you may know, following the announcement of the abolition of the DIFC LCIA, all arbitration agreements that refer to that specific institution now go to DIAC, and DIAC have issued new rules. Now, I've heard ever since that announcement, we had a lot of clients say, well, what does that mean? To choosing the DIFC as a seat, should we all go running off to the ADGM? What institution should we be using? And the short answer is the LCIA remains a very, very viable institution, and the DIFC as a seat remains an excellent choice, because it is, we have numerous precedents of arbitral award enforcements. We have a very robust law in the DIFC. ADGM is also an option. What we tend to say is if you have a common law governed contract, you may choose LCIA, DIFC. If it's more civil law, perhaps ICC. But again, that's not a hard and fast rule. It depends on lots of different factors. What institution you choose? There's different fee structures. There's different specialist arbitrators. So but the choice isn't binary in that sense.
Yep. And in terms of, if parties have previously, Rita, 2, 3, 4, 5 years ago, agreed that disputes would be resolved, in DIFC by application of LCIA rules, that clause still holds good, I'm guessing. It's not problematic. You can still apply those rules to the arbitration in the, with a seat in the DIFC.
Yeah, it's only where you've chosen DIFC LCIA to administer your arbitration will DIAC now take over.
They will take over. Sorry, Rita, is that right?
That's right. Okay, so all those arbitrations have now passed on to DIAC. And what's interesting in the law is that the DIFC is the default seat. So unless you choose a different seat, it's DIFC.
Okay. Very interesting, and a very, very good question. A final question then, and this is from Kagdas Bayrak, and it's to everybody. What are the panelists' views in relation to litigation funding within the GCC region? Are there any pitfalls or recommendations which any of the panelists would like to share on this topic? And I'm going to put this out to the floor, really, if there's anyone in particular that would, has a strong view on this and would like to raise their hand.
I can comment on this or start, Rad.
Thank you, Emad. Thank you.
Yeah. I will highlight, according to Saudi law, I think this sort of funding is not recognized according to Saudi law because this might contradict with Sharia law and might be considered as sort of buying debt, and this is prohibited according to Sharia. We received several, requests from clients to highlight on this sort of funding, and or like some of the banks trying to buy debt and fund the litigation process and get the final award or the final collected amount. Because they already bought that debt and settled with the original creditor. But this has been arranged through a side agreement governed by foreign law, foreign court. But if this, if any judgment related to these sort of arrangements wants to be enforced in Saudi, that will not be enforced because they may consider it against public policy and Sharia principles.
Interesting. Thanks, Matt. So what you're saying is, I mean, essentially, if there's a side agreement to that effect regarding that litigation funding, as long as the parties adhere to it, the Saudi authorities won't intervene. But in the event that one of the parties refused to adhere to his obligations, so he was successful in the claim and he didn't then hand over, for example, 50% of the damages to the funder, as was agreed, that funder would struggle to enforce that agreement in front of the Saudi courts. Is that right, Emad?
Exactly. They have to enforce it somewhere outside Saudi law, Saudi jurisdiction.
Yeah, just quickly, Brad, in the UAE, I think just a couple of points here for litigation funding. The first point is that we are seeing an increased number of litigation funders in the UAE and in the region in general, especially in the context of arbitration cases and obviously the DIFC and common law courts in the region. But in litigation side, we are not seeing a lot. We have seen some, but not a lot in the local onshore courts cases. The other point is that unlike Saudi, in the UAE, whatever litigation funding arrangement you have, most of them are enforceable in the UAE. We have seen live cases in the context of even bankruptcy case where some creditors tried to challenge the litigation funders fee arrangement, and the case was actually dismissed and the court upheld the litigation funding arrangement. So these are the 2 points from my side from UAE law perspective.
Thank you, Naief.
Right, in the DIFC, litigation funding is welcome. I've been in cases where there have been litigation funders on the other side. I think for the right case, it might not be such a bad move. I think that there are lots of clients out there now who do have the funding to run a case, but prefer to use funders just to keep that liquidity. And I'm also seeing, I mean, as Naief said, there's so many funders now trying to come into this market. They're also very interested in buying awards and then just taking forward the enforcement themselves. So if you're a bank, if you're an entity sitting around with lots of unenforced awards or judgments or bad debts accumulating, you might think about, having a funder come in and potentially buy that portfolio. And that's something that they're very interested in for obvious reasons, but it's something that I hear a lot from them.
So we're seeing more of that then, Rita and Naief, I think in the UAE is becoming, more recognized as a commercial concept and, not problematic then from a legal perspective either, it seems. And I think, again, this is another one of those areas where I think in the sort of coming 2 or 3 years, it'll be very interesting to see, how this area develops in terms of how, how normalized those kind of litigation funding, structures and operators, become, because in the UK and, in particular, they're very, very common.
That's right. Yeah, that's right. But just to make sure that this is a general kind of, not a specific advice on the litigation funding arrangements, and each case of course is different. So you have to be careful, obviously, but in general, that's the approach in the UAE. Sure.
Okay, I have a question for Qatar, for Roy. could you briefly discuss, and it's from Siddharth Nair, could you discuss the position of Qatari courts in cases where the parties submit to a foreign jurisdiction in a contract? Okay, so I think we spoke about this about some other jurisdictions, but I don't know if we spoke about Qatar in particular. Can the parties still approach the local courts in Qatar, considering its sovereignty over all matters within the country? So I suppose the question in essence, Roy, is submission to a foreign jurisdiction in a contract that concerns a party or parties in Qatar, is that binding, and would the courts respect that?
Well, the procedures law in Qatar is silent about the private international jurisdiction, unlike some other jurisdiction. There is a couple of judgments issued put the criteria about this, but little bit old, I would say, judgment. So I don't feel comfortable to say that Qatar will have exclusive jurisdiction for all legal matters related to Qatar. I think it's I don't feel comfortable to say this. I would say maybe yes, it's easier for the Qatari court to take jurisdiction, but it's not impossible to apply foreign jurisdiction. I would say it's case by case. It's about the contract itself. There is some matters exclusive for Qatar jurisdiction, but I would not say all the matters. So I would say it's case by case, and I prefer to discuss it. It depends on the contract itself and what has been done, because some contract, part of it is executed in Qatar, part of it's out of Qatar. So all these elements will play a role about the jurisdiction.
Right. So it's not clear cut then, Roy, and it will very much depend on the subject matter.
It's not a black and white. No, I know that many of my colleagues would say it's black and white answer. For me, it's not, because I saw some judgment. I work on many cases when the Qatari court dismissed the case for lack of jurisdiction.
Right. Okay. So to quote the mythical lawyer's favorite term, it really does depend. Okay. It really depends on a case by case basis. Okay, we have literally 2 or 3 minutes left, so I'm just going to direct things to Saudi Arabia briefly. Omar Gouda asks the question. So for the Saudi jurisdiction enforcement, the New York Convention is not fully enforceable. That is, if the arbitration verdict is issued from Dubai for a case where Chinese law is applicable, it shall not be enforceable in Saudi Arabia for conflicting to Sharia law. Emad, what do you make of that?
No, I don't think that this is accurate. I think like Saudi jurisdiction enforce the New York Convention or enforce foreign awards according to the New York Convention. However, if there is any particular part in that foreign award which contradicts with Sharia law, that part will not be enforced.
Okay.
Like the interest.
Okay.
Even if there is a Chinese law applied on that arbitration, or UK law, name it. So the only thing is the part which contradicts with the Sharia law will not be enforced. However, if all is in compliance with Sharia law, the arbitral award will be enforced according to New York Convention.
Perfect. Thank you very much, Emad. I think that brings us to the end of our webinar today. I would just like to thank all of our panelists, Roy, Rita, Omar, Emad, Noor, and Naief. Thank you very much indeed, guys. I'd like to thank all of the attendees for attending today, and I hope you've found it to be informative and engaging. You know, in terms of feedback from you guys, look, you know, we would love to roll out more of these seminars that are sort of dispute resolution, litigation, arbitration focused. If you have any suggestions as to sort of future topics, what you'd like us to focus in on and so on, you can reach out to myself or any of the panelists today. Equally, guys, if you have any follow-up questions, you can contact any of the panelists or myself, and we'll do our best to address those. And thank you very much for attending, and we look forward to seeing you next time.
Everyone.
Thank you, everyone.
Thanks, guys.
Bye-bye.
Thank you, everyone. Bye-bye.
Bye.